Chapter 8 deleted. Section 1 deleted. Articles 980 through 983 deleted. Less than by Act No. 7427, March 31, 2005. Greater than. Article 981 deleted. Less than by Act No. 7427, March 31, 2005. Greater than. Article 982 deleted. Less than by Act No. 7427, March 31, 2005. Greater than. Article 983 deleted. Less than by Act No. 4199, January 13, 1990. Greater than. Section 2 deleted. Article 984 deleted. Less than by Act No. 7427, March 31, 2005. Greater than. Article 985 deleted. Less than by Act No. 7427, March 31, 2005. Greater than. Article 986 deleted. Less than by Act No. 7427, March 31, 2005. Greater than. Article 987 deleted. Less than by Act No. 7427, March 31, 2005. Greater than. Article 988 deleted. Less than by Act No. 4199, January 13, 1990. Greater than. Article 989 deleted. Less than by Act No. 7427, March 31, 2005. Greater than. Article 990 deleted. Less than by Act No. 4199, January 13, 1990. Greater than. Article 991 deleted. Less than by Act No. 7427, March 31, 2005. Greater than. Article 992 deleted. Less than by Act No. 7427, March 31, 2005. Greater than. Article 993 deleted. Less than by Act No. 7427, March 31, 2005. Greater than. Article 994 deleted. Less than by Act No. 7427, March 31, 2005. Greater than. Section 3 to 0. Article 995 deleted. Less than by Act No. 7427, March 31, 2005. Greater than. Article 996 deleted. Less than by Act No. 4199, January 13, 1990. Greater than. Part versus inheritance. Chapter I Inheritance. Section 1 General Provisions. Article 997. Causes for commencement of inheritance. An inheritance shall be commenced by death, less than amended by Act No. 4199, January 13, 1990, greater than. Article 998. Place of commencement of inheritance. An inheritance shall be commenced at the place of domicile of the inheritee. This article wholly amended by Act No. 4199, January 13, 1990. Article 998-2. Expenses for inheritance. Expenses for inheritance shall be paid out of the inherited property. This article newly inserted by Act No. 4199, January 13, 1990. Article 999. Claim for recovery of inheritance. 1. If the right of inheritance is infringed by a person who pretends to have the right of inheritance, the person who has the right of inheritance or his/her legal representative may bring an action for recovery of inheritance. 2. The claim for recovery of inheritance under paragraph 1 shall lapse at the expiration of 3 years from the date he comes to know the infringement, or 10 years from the date the right of inheritance is infringed. Less than amended by Act No. 6591, January 14, 2002, greater than. This article wholly amended by Act No. 4199, January 13, 1990. Section 2 Inheritor. Article 1000. Priority of inheritance. 1. In inheritance, persons become inheritors in the following order, less than amended by Act No. 4199, January 13, 1990, greater than. 1. Lineal descendants of the inheritee. 2. Lineal ascendants of the inheritee. 3. Brothers and sisters of the inheritee, and 4. Collateral blood relatives within the fourth degree of the inheritee. 2. In the case mentioned in paragraph 1, if there are 2 or more inheritors standing in the same order, the closest in degree of relationship shall have the priority of inheritance. If there are 2 or more inheritors standing in the same degree of relationship, they become co-inheritors. 3. With respect to the order of inheritance, an unborn child shall be considered as born. Less than amended by Act No. 4199, January 13, 1990, greater than. Article 1001. Inheritance by representation. Where a lineal descendant or a brother or sister who would become an inheritor in accordance with the provisions of Article 1001, 1 and 3, has died, or has become disqualified before the commencement of succession, his or her lineal descendants, if any exist, shall become inheritors in the order in which the deceased or disqualified person would have become the inheritor. Article 1002 deleted. Less than by Act No. 4199, January 13, 1990, greater than. Article 1003. Order of inheritance of spouse. 1. If there exist such inheritors as provided in Article 1001, 1 and 2, the spouse of the inheritee becomes a co-inheritor, in the same order as the said inheritor. If there exists no inheritor, the spouse becomes the sole inheritor. Less than amended by Act No. 4199, January 13, 1990, greater than. 2. In the case mentioned in Article 1001, the spouse of the deceased or the disqualified person, before the commencement of inheritance, becomes a co-inheritor in the same order as the inheritors provided in the same article. If there exists no inheritor, the spouse becomes the sole inheritor. Less than amended by Act No. 4199, January 13, 1990, greater than. Article 1004. Cause whereby inheritor becomes disqualified. No person who falls under any one of the following subparagraphs may become the inheritor. Less than amended by Act No. 4199, January 13, 1990. Act No. 7427, March 31, 2005. Greater than 1. A person who has intentionally killed or attempted to kill a lineal ascendant, the inheritee, his or her spouse, or any person who has priority or is in the same order of inheritance. 2. A person who has intentionally assaulted a lineal ascendant, the inheritee or his or her spouse, and caused their death. 3. A person who interferes by fraud or duress with a will or withdrawal of a will on inheritance of the inheritee. 4. A person who, by fraud or duress, has the inheritee make a will on his or her inheritance, and 5. A person who forges, alters, destroys or conceals a will on inheritance of the inheritee. Section 3. Effects of inheritance. Subsection 1. General effect. Article 1005. Inheritance and succession of blanket rights and duties. An inheritor succeeds, from the time of the commencement of the inheritance, to the blanket rights and duties pertaining to the property of the inheritee, provided that this shall not apply to the property which is entirely personal to the inheritee. Less than amended by Act No. 4199, January 13, 1990. Greater than. Article 1006. Joint inheritance and co-ownership of inherited property. If there exist two or more inheritors, they become co-owners of the inherited property. Less than amended by Act No. 4199, January 13, 1990. Greater than. Article 1007. Co-inheritors' succession to rights and duties of inheritee. Each of the co-inheritors succeeds to the rights and duties of the inheritee in proportion to his share of the inheritance. Article 1008. Shares of inheritance for special beneficiary. If any one of the co-inheritors has previously received a gift or testamentary gift of property from the inheritee, and such property received is of less value than his share of the inheritance, he shall be entitled to a share of the inheritance within the limit of the difference between the said gifts and his legal share of the inheritance. Less than amended by Act No. 3051, December 31, 1977. Greater than. Article 1008-2. Contributory portion. 1. If there is a person among co-inheritors who has specially supported the inheritee through sharing living accommodations or providing nursing, etc. for a considerable period, or has specially contributed to the maintenance or increase of the property of the inheritee, the value, calculated by deducting his contributory portion, is determined by an agreement of co-inheritors from the value of property of the inheritee at the time the inheritance is commenced, shall be considered as an inherited property. The amount calculated by adding such contributory portion to the inherited portion calculated under Articles 1009 and 1010 shall be the inherited portion of that person. Less than amended by Act No. 7427, March 31, 2005. Greater than. 2. If co-inheritors fail to reach an agreement under paragraph 1, or if it is impossible to reach an agreement, the family court shall, upon the request of the contributor under paragraph 1, determine the contributory portion, taking into consideration the time, method and degree of the contribution, the value of the inherited property and other circumstances. 3. The contributory portion shall not exceed the amount calculated by deducting the value of testamentary gifts from that of property of the inheritee when the inheritance is commenced. 4. The request under paragraph 2 may be made when a request is made under Article 1013, 2, or as provided in Article 1014. This article newly inserted by Act No. 4199, January 13, 1990. Article 1008-3, Inheritance of graveyards, etc. The right of ownership in forest land not more than 2.451 acres for graves and farmland for management of graves less than 1983.48 square meters, a genealogy, and ritual implements shall be succeeded to by the person who superintends the ancestral rites. This article newly inserted by Act No. 4199, January 13, 1990. Subsection 2 Shares of inheritance. Article 1009. Legal portions in inheritance. 1. If there exist two or more inheritors in the same rank, their shares of the inheritance shall be equally divided. Less than amended by Act No. 3051, December 31, 1977. Act No. 4199, January 13, 1990 greater than. 2. The portions inherited to an inheritee's spouse shall be increased by 50% over the inherited portion of his or her lineal descendant where he or she inherits jointly with his or her descendants, or 50% over the inherited portion of his or her lineal ascendant where he or she inherits jointly with his or her lineal ascendants. Less than amended by Act No. 4199, January 13, 1990 greater than. 3. Deleted. Less than by Act No. 4199, January 13, 1990 greater than. Article 1010. Shares of inheritance by representation. 1. The portion inherited by the person who becomes an inheritor in place of the deceased or disqualified person in accordance with the provisions of Article 1001 shall be that of the deceased or the disqualified person. 2. In the case mentioned in paragraph 1, if there exist two or more lineal descendants of the deceased or disqualified person, their shares of the inheritance shall be determined in accordance with the provisions of Article 1009, within the limit of the share of the inheritance of the deceased or disqualified person. The same shall also apply to the cases mentioned in Article 1003, 2. Article 1011. Assignment of common shares in joint inheritance. 1. If one of the co-inheritors assigns his or her share of the inheritance to a third person, any other co-inheritor may obtain such share by transfer upon effecting a reimbursement of its value and expenses relating to the transfer. 2. The right mentioned in paragraph 1 shall be exercised within 3 months from the day on which such cause has been known or within 1 year from the day on which such cause has occurred. Subsection 3 Division of inherited property. Article 1012. Determination of method division or forbidding division by will. An inheritee may by will determine the method of division of the inherited property, entrust a third person with such determination, or forbid division for a period not exceeding 5 years from the time of the commencement of the inheritance. Article 1013. Division by agreement. 1. Except as mentioned in Article 1012, co-inheritors may, at any time, effect the division of the inherited property by their agreement. 2. The provisions of Article 269 shall apply mutatis mutandis to the division of the inherited property mentioned in paragraph 1. Article 1014. Right to apply for division by person, etc. Affiliated after division of inherited property. Where a person who has become a co-inheritor by affiliation or by a final judgment after the commencement of the inheritance applies for the division of inherited property, he or she may, if other co-inheritors have already effected the partition or other disposition, claim payment of the amount equivalent to his or her portion. Article 1015. Retroactive effect of division. Division of an inherited property shall be effective retroactively from the time of the commencement of the inheritance, provided that the rights of third persons shall not be prejudiced thereby. Article 1016. Liability for warranty to be borne by co-inheritor. Each co-inheritor shall, in proportion to his or her share of the inheritance, bear the same liability for warranty as that of a seller towards other co-inheritors with regard to the property acquired by them through division. Article 10(17). Liability for warranty for solvency of obliger to inheritance. 1. Each co-inheritor shall, in proportion to his or her share of the inheritance, warrant the solvency of the obliger as of the time of division with regard to claims acquired by other co-inheritors through division. 2. With regard to an obligation which is not yet due or an obligation subject to a condition precedent, each co-inheritor warrants the solvency of the obliger at the time of performance. Article 10(18). Apportionment of warranty liability of insolvent co-inheritor. If there is an insolvent person among co-inheritors liable for warranty, the portion of liability which such person is to bear is apportioned to those having the right to claim for reimbursement and other solvent co-inheritors in proportion to their inherited portions, provided that if the person who has the right to claim reimbursement fails to receive any reimbursement due to his own negligence, he may not make a demand upon the other co-inheritors to bear their portions. Section 4. Acceptance and renunciation of inheritance. Subsection 1. General provisions. Article 10(19). Period for acceptance and renunciation. 1. An inheritor to property may, within 3 months after he is informed of the commencement of an inheritance, effect an acceptance, absolute or qualified, or a renunciation, provided that such period may be extended by the family court upon the application of any party interested or of a public prosecutor. Less than amended by Act No. 4199, January 13, 1990. Greater than. 2. An inheritor may examine the inherited property before effecting such acceptance or renunciation as mentioned in paragraph 1. Less than amended by Act No. 6591, January 14, 2002. Greater than. 3. Notwithstanding the provisions of paragraph 1, where an inheritor has made an absolute acceptance, including the case deemed to have made an absolute acceptance under subparagraphs 1 and 2 of Article 1026, without knowing the fact that his inherited liability exceeds his inherited property within the period under paragraph 1, without any gross negligence, a qualified acceptance may be made within 3 months from the date on which he knew such fact. Less than newly inserted by Act No. 6591, January 14, 2002. Greater than. Article 1020. Period for acceptance and renunciation by person with limited capacity. If an inheritor is a person with limited capacity, the period referred to in Article 1019, 1, shall be calculated from the time his/her legal representative becomes aware that the inheritance has been commenced. This article wholly amended by Act No. 10429, March 7, 2011. Article 1021. Special rule governing calculation of period for acceptance or renunciation. Where an inheritor dies without effecting either acceptance or renunciation within the period mentioned in Article 1019, 1, the period mentioned in Article 1019, 1, shall be calculated from the time when his inheritor becomes aware that the inheritance has been commenced in his favor. Article 1022. Management of inherited property. An inheritor shall manage the inherited property with the same care as he uses with respect to his own property, provided that this shall not apply when the inheritor has effected either absolute acceptance or renunciation. Article 1023. Disposition necessary for preservation of inherited property. 1. The court may, upon the application of any party interested or of a public prosecutor, at any time, order a disposition as may be necessary for the preservation of the inherited property. 2. Where the court appoints an administrator for property, the provisions of Articles 24 through 26 shall apply mutatis mutandis. Article 1024. Prohibition of revocation of acceptance or renunciation. 1. Acceptance or renunciation of inheritance may not be revoked even within the period mentioned in Article 1019, 1. Less than amended by Act No. 4199, January 13, 1990 greater than. 2. The provisions of paragraph 1 shall not affect the voidance in accordance with the provisions of Part 1, General Provisions, provided that such right of voidance shall be extinguished by prescription, if it is not exercised within 3 months from the day on which it became possible to effect ratification, or within 1 year from the day on which acceptance or renunciation was effected. Subsection 2. Absolute acceptance. Article 1025. Effect of absolute acceptance. If an inheritor effects an absolute acceptance, he shall succeed without limitation to the rights and duties of the inheritee. Less than amended by Act No. 4199, January 13, 1990 greater than. Article 1026. Absolute acceptance by law. An inheritor shall be deemed to have effected an absolute acceptance in any of the following cases. Less than amended by Act No. 6591, January 14, 2002 greater than. 1. If an inheritor has taken an act of disposition with regard to the inherited property. 2. If an inheritor has failed to effect either a qualified acceptance or a renunciation within the period mentioned in Article 1019, 1, and less than this subparagraph was amended by Act No. 6591, January 4, 2002 according to the decision of the Constitutional Court as unconstitutional on August 27, 1998 greater than. 3. If an inheritor, after having effected a qualified acceptance or a renunciation, has concealed or fraudulently consumed, or failed intentionally to enter in the inventory, the inherited property. Article 1027. Exception to absolute acceptance by law. If an inheritor of second priority has accepted an inheritance owing to renunciation of inheritance effected by the inheritor, the cause mentioned in subparagraph 3 of Article 1026 shall not be deemed as an acceptance of inheritance. Subsection 3. Qualified acceptance. Article 1028. Effect of qualified acceptance. An inheritor may effect an acceptance of inheritance on the condition that he shall perform the obligations and testamentary gift of the inheritee only to the extent of the property to be acquired through the inheritance. Less than amended by Act No. 4199, January 13, 1990 greater than. Article 1029. Qualified acceptance by co-inheritors. If there exist 2 or more inheritors, each inheritor may effect an acceptance of inheritance on the condition that he shall perform in proportion to his share of the obligations and testamentary gift of the inheritee only to the extent of the property to be acquired in proportion to his share of the inheritance. Article 1030. Method of qualified acceptance. 1. If an inheritor desires to effect a qualified acceptance, he shall file a report of qualified acceptance, attaching an inventory of the inherited property, with the court within the period mentioned in Article 1019, 1, or 3. Less than amended by Act No. 7427, March 31, 2005 greater than. 2. In effecting a qualified acceptance pursuant to Article 1019, 3. If there is any property, among the inherited properties, which is already disposed of, its inventory and value shall be submitted together. Less than newly inserted by Act No. 7427, March 31, 2005 greater than. Article 1031. Qualified acceptance and non-extinction of rights and duties over property. Where an inheritor effects a qualified acceptance, any rights and duties over property which he had towards the inheritee shall be deemed not to have been extinguished. Article 1032, Public Notice and Peremptory Notice towards Obliges. 1. A qualified acceptor shall, within 5 days after he has effected the qualified acceptance, notify the general obliges in succession and the testamentary donnees by public notice that he has effected a qualified acceptance and that they are called upon to notify him of their claims or testamentary gifts within a specified period of not less than 2 months. 2. The provisions of Articles 88, 2, and 3, and 89 shall apply mutatis mutandis to the cases mentioned in paragraph 1. Article 1033, Refusal of performance within period of peremptory notice. A qualified acceptor may refuse performance of obligations relating to inheritance until the expiration of the period mentioned in Article 1032, 1. Article 1034, Performance by distribution. 1. A qualified acceptor shall, upon the expiration of the period mentioned in Article 1032, 1. Effect performance to obliges who have notified him of their claims within such period, and to all other obliges known to him, in proportion to the amounts of their respective claims of the inherited property, provided that the rights of the obliges who have priority may not be prejudiced thereby. 2. Where a qualified acceptance is made pursuant to Article 1019, 3, the inheritor shall effect the performance of paragraph 1. By adding up the amounts of the remaining inherited property and the inherited property already disposed of, provided that the amount of performance which is already effected to obliges in inheritance or testamentary donnees before such a qualified acceptance is made shall be excluded from the amount of the property which is already disposed of, less than newly inserted by Act No. 7427, March 31, 2005 greater than. Article 1035, Performance of obligations, etc., which are not yet due. 1. A qualified acceptor shall perform in accordance with the provisions of Article 1034 even those obligations which are not yet due. 2. Conditional obligations or obligations with uncertain duration shall be performed according to the valuation of an expert appointed by the court. Article 1036, Performance to testamentary donnees. A qualified acceptor may not effect performance to testamentary donnees until he has completed performance to all obliges inherited in accordance with the provisions of Articles 1034 and 1035. Article 1037, Sale of inherited property by auction. When it is necessary to sell out some or all of the inherited properties in order to perform the obligations in accordance with the provisions of Articles 1034 through 1036, an auction shall be held pursuant to the Civil Execution Act, less than amended by Act No. 5454, December 13, 1997, Act No. 6544, December 29, 2001 greater than. Article 1038, Liability arising from unfair performance, etc. 1. If a qualified acceptor has neglected to give a public or peremptory notice pursuant to the provisions of Article 1032, or has effected performance to some obliges in inheritance or testamentary donnees in violation of the provisions of Articles 1033 through 1036, and in consequence has become unable to effect performance to the other obliges in inheritance or testamentary donnees, he shall redress any damages arising therefrom. This shall also apply to the cases where the inheritor who has neglected to know the fact that his inherited liability exceeds his inherited property but has made a qualified acceptance pursuant to Article 1019, 3, had effected performance to some obliges in inheritance or testamentary donnees before such a qualified acceptance, less than amended by Act No. 7427, March 31, 2005 greater than. 2. In the case of the former part of paragraph 1, any obligee in inheritance or testamentary donnee to whom no performance has been effected, may exercise the right to demand reimbursement from such obliges in the inheritance or testamentary donnees, as having improperly received performance with knowledge of the circumstances. This shall also apply to the cases where there are obliges in inheritance or testamentary donnees who have received performance from the inheritor, who has made a qualified acceptance pursuant to Article 1019, 3, before such a qualified acceptance with knowledge that the inherited liability exceeds the inherited property. less than amended by Act No. 7427, March 31, 2005 greater than. 3. The provisions of Article 766 shall apply mutatis mutandis to the cases mentioned in paragraphs 1 and 2. Less than amended by Act No. 7427, March 31, 2005 greater than. Article 1039, obliges, etc. who fail to give notice of their claims. Obliges in inheritance and testamentary donies who have failed to give notice of their claims within the period mentioned in Article 1032, 1, and who were unknown to the qualified acceptor, may receive performance only where there is any surplus of the inherited property, provided that this shall not apply where obliges to the inherited property and testamentary donies have special security interest with respect to the inherited property. Article 1040. Property jointly inherited and appointment of administrator thereof. 1. Where there exist two or more inheritors, the court shall, upon the request of each inheritor or interested person, appoint an administrator of the inherited property among the co-inheritors. 2. The administrator appointed by the court shall have the right and duty to perform all acts relating to management of the inherited property and perform obligations on behalf of the co-inheritors. 3. The provisions of Articles 1022 and 1032 through 1039 shall apply mutatis mutandis to the administrator mentioned in paragraph 2, provided that the period of 5 days of public notice to be given in accordance with the provisions of Article 1032 shall be calculated from the day on which an administrator became aware of his appointment. Subsection 4 Renunciation. Article 1041, Method of Renunciation. If an inheritor to property effects a renunciation of an inheritance, he shall make a declaration of renunciation to the family court within the period mentioned in Article 1019, 1. Less than amended by Act No. 4199, January 13, 1990 greater than. Article 1042, Retroactive Effect of Renunciation. A renunciation of inheritance shall be effective retroactively from the time of the commencement of the inheritance. Article 1043, Reversion of renounced inherited property. Where there exist two or more inheritors, and one of them has effected a renunciation of inheritance, his share of the inheritance shall revert to the other inheritors in proportion to their respective shares thereof. Article 1044, Duty to continue management of renounced inherited property. 1. A person who has effected a renunciation of inheritance shall continue to manage the inherited property until the person who becomes inheritor by reason of renunciation is able to undertake the management of the property. 2. The provisions of Articles 1022 and 1023 shall apply mutatis mutandis to the management of the property mentioned in paragraph 1. Section 5 Separation of property. Article 1045, Right to apply to court for separation of inherited property. 1. An obligee in inheritance, or a testamentary donee, or an obligee of an inheritor, may, within 3 months from the time of the commencement of the inheritance, apply to the court for the separation of the inherited property from the inherent property of the inheritor. 2. An application may be filed with the court for the separation of property even after the period mentioned in paragraph 1 elapses, until such time as an inheritor has not accepted or renounced the pertinent inheritance. Less than amended by Act No. 4199, January 13, 1990 greater than. Article 1046, Order to separate property, and pubic and peremptory notice to obliges, etc. 1. If the court has ordered a separation of property on an application as mentioned in Article 1045, the applicant shall, within 5 days, give public notice to the general obliges in inheritance and to testamentary donees, that an order for a separation of property has been issued and that they are called upon to give a notice of their claims or testamentary gifts within a specified period of not less than 2 months. 2. The provisions of Articles 88, 2, and 3, and 89 shall apply mutatis mutandis to the cases mentioned in paragraph 1. Article 1047. Management of inherited property after separation of property. 1. Where the court has ordered a separation of property, it may order the adoption of such measures as may be necessary for the management of the inherited property. 2. Where the court has appointed an administrator of property, the provisions of Articles 24 through 26 shall apply mutatis mutandis. Article 1048. Inheritors' duty to manage property inherited after separation of property. 1. Even after an inheritor has effected an absolute acceptance, and if a separation of property has been ordered, the inheritor shall henceforth manage the inherited property with the same care as he uses with respect to his own property. 2. The provisions of Articles 683 through 685, and 688, 1, and 2, shall apply mutatis mutandis to the management of property mentioned in paragraph 1. Article 1049. Condition to set up against third person in case of separation of property. As to immovable inherited property, a separation of property cannot be set up against a third person unless it has been registered. Article 1050. Separation of property and non-extinguishment of right and duty. Where a separation of property has been ordered, the rights and duties of the inheritor to the inheritee with respect to the property shall not become extinguished. Article 1051. Refusal of performance and performance by distribution. 1. An inheritor may refuse performance to obliges in inheritance, and to testamentary donees, until the expiration of the periods mentioned in Articles 1045 and 1046. 2. The inheritor shall, upon the expiration of the period mentioned in paragraph 1, effect performance, out of the inherited property, to obliges in inheritance and testamentary donees who applied for the separation of property or who have notified within such period, and to obliges in inheritance and testamentary donees known to the inheritor, in proportion to their amount of obligations or testamentary gifts, provided that the rights of obliges who have priority may not be prejudiced thereby. 3. The provisions of Articles 1035 through 1038 shall apply mutatis mutandis to the cases mentioned in paragraph 2. Article 1052. Performance of obligation out of inherent property. 1. The obliges in inheritance and testamentary donees pursuant to the provisions of Article 1051 may be entitled to receive performance out of the inherent property of the inheritor only where they are unable to receive full performance from the inherited property. 2. In the case mentioned in paragraph 1, the obliges of the inheritor shall have the right to receive performance in preference to other persons out of the inherent property of the inheritor. Section 6. Absence of inheritor. Article 1053. Administrator of property of which inheritor does not exist. 1. If it is unknown whether an inheritor exists, the court shall, upon the application of any relative of the inheritee pursuant to the provisions of Article 777 or any other interested person or the public prosecutor, appoint an administrator of the inherited property, and shall publicly announce the matter without delay. Less than amended by Act No. 4199, January 13, 1990 greater than. 2. The provisions of Articles 24 through 26 shall apply mutatis mutandis to the administrator of property mentioned in paragraph 1. Article 1054. Presentation of inventory of property and report on status of property. If a demand is made by any of the obliges in inheritance or testamentary donees, the administrator shall at any time present the inventory of the inherited property and report the status thereof. Article 1055. Cases in which existence of inheritor becomes clear. 1. The duty of an administrator shall be terminated at the time when an inheritor effects an acceptance of inheritance. 2. In the case mentioned in paragraph 1, the administrator shall render an account of the management of the inherited property without delay. Article 1056. Liquidation of property of which inheritor does not exist. 1. If it is unknown within 3 months after the public notice mentioned in Article 1053, 1, has been given whether an inheritor exists, the administrator shall, without delay, give public notice to the general obliges in inheritance and testamentary donies, calling upon them to give him notice of their claims or testamentary gifts within a specified period of not less than 2 months. 2. The provisions of Articles 88, 2, and 3, 89, and 1033 through 1039 shall apply mutatis mutandis to the cases mentioned in paragraph 1. Article 1057. Public notice in order to search inheritor. If, after the expiration of the period mentioned in Article 1056, 1, it is still unknown whether an inheritor exists, the court shall, upon the application of the administrator, give public notice calling upon the inheritors, if any, to assert their rights within a specified period of not less than 1 year. Less than amended by Act No. 7427, March 31, 2005 greater than. Article 1057-2, Apportionment for person having special connection. 1. If no person asserts his right to inheritance within the period as prescribed in Article 1057, the family court may apportion all or part of the inherited property upon the request of those who have lived together with the inheritee, have provided the inheritee with medical and nursing care, or have had a special relationship with him. Less than amended by Act No. 7427, March 31, 2005 greater than. 2. The request as referred to in paragraph 1 shall be made within 2 months after the period prescribed in Article 1057 expires. Less than amended by Act No. 7427, March 31, 2005 greater than. This article newly inserted by Act No. 4199, January 13, 1990. Article 1058, Escheatment of inherited property. 1. If there is any inherited property which is not apportioned pursuant to Article 1057-2, the inherited property shall be escheated to the state. Less than amended by Act No. 7427, March 31, 2005 greater than. 2. The provisions of Article 1055, 2, shall apply mutatis mutandis to the cases of paragraph 1. Less than amended by Act No. 7427, March 31, 2005 greater than. Article 1059, Prohibition on demanding performance with respect to property escheated. In the case mentioned in Article 1058, 1, even if there exist any obliges in inheritance or testamentary donies who have not received any performance out of the inherited property, no demand of such performance may be filed against the state. Chapter 2 Wills. Section 1 General Provisions. Article 1060, Formality of Wills. No will shall take effect unless he is in conformity with the formality stipulated by this Act. Article 1061, Eligible age to make will. Any person who has not attained full 17 years of age may not make a will. Article 1062, Wills of persons with limited capacity. Articles 5, 10 and 13 shall not apply to wills. This article wholly amended by Act No. 10429, March 7, 2011. Article 1063. Capacity of adult wards to make wills. 1. An adult ward may make a will only when she has recovered to the point of understanding her intentions. 2. In cases falling under paragraph 1, a medical practitioner shall add in writing the status of recovery of mental soundness on the testament, and shall affix her signature and seal thereto. This article wholly amended by Act No. 10429, March 7, 2011. Article 1064. Will and unborn child an ineligible person for succession. The provisions of Articles 1003 and 1004 shall apply mutatis mutandis to a testamentary donee. Less than amended by Act No. 4199, January 13, 1990 greater than. Section 2 Forms of Wills. Article 1065, Ordinary Form of Wills. There shall be 5 forms of wills as follows: holograph document, sound recording, notarial and secret documents, and instrument of dictation. Article 1066, Will by holograph document. 1. In order to make a will by holograph document, the testator must write with his own handwriting the whole text, the date, the domicile, and his full name, and must affix his seal thereto. 2. In order to make any insertion, deletion, or other alteration of letters in a holograph mentioned in paragraph 1, such correction must be made in the testator's own handwriting and affix his seal thereto. Article 1067, Will by sound recording. In order to make a will by a sound recording, the testator must orally state the tenor of his will, his full name and the date, and the witness must orally state that the will made by the testator is due and correct, and also state his full name. Article 1068, Will by notarial document. In order to make a will by a notarial document, the testator must orally state the tenor of his will before a notary, in the presence of 2 witnesses, and the notary must write down and read it, and then the testator and each of the witness must affix their signature or names and seals to the writing after acknowledging it to be due and correct. Article 1069, Will by secret document. 1. In order to make a will by a secret document, the testator must close up the document on which the writer's full name was written and affix his seal thereto, and after the testator has produced the sealed document before at least 2 witnesses and declares that it is his testamentary document, the date of the production of the document must be written on the sealed cover, and then the testator and the witnesses must affix their signatures or names and seals thereto. 2. A closed document of a will prepared in compliance with the forms mentioned in paragraph 1 must be submitted to a notary or the court clerk within 5 days from the day on which the date of production of the document has been written down on the cover of the document, and the date of confirmation thereof must be affixed on the part sealed. Article 1070, Will by instrument of dictation. 1. In order to make a will by an instrument of dictation where a will is not able to be made in compliance with the forms mentioned in the preceding 4 articles due to disease or any other cause imminent, the testator must orally declare the tenor of his will to one of the witnesses in the presence of at least 2 witnesses, and the person to whom the oral declaration is made must write it down and read it, and the testator and each witness, after their having acknowledged the writing to be due and correct, must affix their signature and seal thereto. 2. A will made in compliance with the form mentioned in paragraph 1 must be submitted to the court for its inspection and approval thereof by the witness or the persons interested within 7 days from the day on which such imminent cause terminates. 3. The provisions of Article 1063, 2, shall not apply to a will to be made by an instrument of dictation. Article 1071, Conversion of will made by secret document. If a will which has been made by a secret document is defective as to formalities, he shall be deemed as a holograph will if he fulfills the formalities of a holograph document. Article 1072. Ineligibility for witnesses. 1. None of the following persons shall become a witness to the preparation of a will. 1. A minor. 2. An adult ward and limited ward. 3. A person to be benefited by a will, his, her spouse, or lineal blood relatives. 2. Any person who is ineligible pursuant to the Notary Public Act shall not become a witness to the preparation of a notarial will. This article wholly amended by Act No. 10,429, March 7, 2011. Section 3. Effect of wills. Article 1073. Time for effectiveness of wills. 1. A will becomes effective upon the death of the testator. 2. Where a will is subject to a precedent condition, and the condition is fulfilled after the death of the testator, the will becomes effective upon the fulfillment of the condition. Article 1074. Acceptance or renunciation of testamentary gift. 1. A testamentary donee may effect an acceptance or a renunciation of the testamentary gift at any time subsequent to the death of the testator. 2. The acceptance or renunciation mentioned in paragraph 1 shall be effective retroactively from the time of the death of the testator. Article 1075. Prohibition of revocation of acceptance or renunciation of testamentary gift. 1. An acceptance or a renunciation of a testamentary gift cannot be revoked. 2. The provisions of Article 1024, 2, shall apply mutatis mutandis to the acceptance and renunciation of testamentary gifts. Article 1076. Acceptance or renunciation of inheritor to testamentary donee. Where a testamentary donee dies without effecting either an acceptance or a renunciation of the testamentary gift, his inheritor can effect an acceptance or a renunciation within the limits of his share of the inheritance, provided that if the testator has declared a different intention in his will, such intention shall prevail. Article 1077. Right to give peremptory notice by person charged with testamentary gift. 1. A person charged with a testamentary gift or any interested person may, by fixing a reasonable period, give a peremptory notice to the testamentary donee or his inheritor to furnish within such period a definite answer as to whether he would effect an acceptance or a renunciation of the testamentary gift. 2. If the testamentary donee or his inheritor fails to furnish a definite answer to the person charged with the testamentary gift within the period mentioned in paragraph 1, he shall be deemed to have accepted the testamentary gift. Article 1078. Rights and duties of testamentary donee by universal title. A testamentary donee by a universal title has the same rights and duties as an inheritor. Less than amended by Act No. 4199, January 13, 1990. Greater than. Article 1079. Testamentary donee's right to acquire fruits. A testamentary donee acquires the fruits bearing on the subject of the testamentary gift from the time when he can demand fulfillment of the testamentary gift, provided that if the testator has declared a different intention in his will, such intention shall prevail. Article 1080. Right to demand reimbursement of expenses incurred for purpose of collecting fruits. If the person charged with a testamentary gift defrays necessary expenses for the purpose of collecting the fruits of the subject of the testamentary gift after the death of the testator, he may make a demand upon the testamentary donee who has acquired the fruits for reimbursement thereof to the extent of the value of the fruits derived therefrom. Article 1081. Right to demand reimbursement of expenses by person charged with testamentary gift. If the person charged with a testamentary gift defrays any expenses with respect to the subject of the testamentary gift after the death of the testator, the provisions of Article 325 shall apply mutatis mutandis. Article 1082. Liability for warranty to be assumed by person charged with unspecified testamentary gift. 1. Where an unspecified item has become the subject of a testamentary gift, the person charged with the testamentary gift shall assume the same liability with respect to the warranty as that of a seller. 2. In the case mentioned in paragraph 1, if any defect exists in the object, the person charged with the testamentary gift shall substitute an item free from any defect for the object. Article 1083. Subrogation for testamentary gift. Where a testator has a right to demand compensation from a third person by reason of the loss or damage of the subject of a testamentary gift or infringement upon the possession thereof, such right shall be deemed to have become the subject of the testamentary gift. Article 1084. Subrogation for testamentary gift of which subject is claim. 1. Where a claim has become the subject of a testamentary gift, and the things which the testator has received by obtaining performance still remain among the inherited property, such things shall be deemed to have become the subject of the testamentary gift. 2. As to a claim mentioned in paragraph 1, for which money is the subject, the amount of such money shall be deemed to have become the subject of the testamentary gift even though there is no sum of money corresponding to the amount of the claim included in the inherited property. Article 1085. Item or right which constitutes subject of testamentary gift. If the item or right which constitutes the subject of a testamentary gift at the time of the death of the testator is the subject of a right belonging to a third person, the testamentary donee may not demand from the person charged with the testamentary gift that such right be extinguished. Article 1086. Cases in which testator has declared different intention in his will. In the cases mentioned in Articles 1083 through 1085, if the testator has declared a different intention in his will, such intention shall prevail. Article 1087. Testamentary gift of right which does not comprise inherited property. 1. A will shall not take effect if the right which forms the subject thereof does not comprise the inherited property at the time of the death of the testator, provided that if the testator had intended that his will should take effect even if the subject of his will does not comprise the inherited property at the time of his death, the person charged with the testamentary gift is under a duty to acquire that right and transfer it to the testamentary donee. 2. In the case of the proviso of paragraph 1, if the person cannot acquire the right or if excessive expense would be required in order to acquire it, he may pay over the value thereof. Article 1088. Testamentary gift subject to charge and responsibility of testamentary donee. 1. A person who has received a testamentary gift subject to a charge is bound to perform the duty which he has assumed only to the extent of the value of the testamentary gift. 2. Where the value of a testamentary gift is reduced by reason of a qualified acceptance of the inheritance or a separation of property, the testamentary donee shall, in proportion to such reduction, be relieved of the duty which he has assumed. Article 1089. Death of testamentary donee before effectiveness of testamentary gift. 1. A testamentary gift shall not be effective if the testamentary donee dies before the death of the testator. 2. A testamentary gift subject to a precedent condition shall not take effect if the testamentary donee dies before the fulfillment of the condition. Article 1090. Null and void testamentary gift and reversion of property subject to testamentary gift. Where a testamentary gift does not take effect, or a testamentary donee renounces a testamentary gift, the property of a testamentary gift reverts to the inheritor, provided that if the testator has declared a different intention in his will, such intention shall prevail. Section 4. Execution of wills. Article 1091. Probate of testamentary document or sound recording. 1. The custodian of a testamentary document or a sound recording, or the person who discovered these, shall after the death of the testator, present them to the court and apply for probate thereof without delay. 2. The provisions of paragraph 1 shall not apply to a will in the form of a notarial document or an instrument of dictation. Article 1092. Opening of testamentary document. Where the court is to open a testamentary document closed with a seal, the inheritors or representatives of the testator or any other interested persons must be present at the opening of such document. Article 1093. Designation of executor. A testator may designate an executor by will or commission a third person to designate an executor. Article 1094. Designation of executor by commission. 1. A third person who has accepted the commission mentioned in Article 1093 must designate an executor without delay after he has knowledge of the commission, and he must give notice thereof to the inheritors. If he desires to decline such commission, he must give notice of such declination to the inheritors. 2. An inheritor and any other interested person may, by fixing a reasonable period, give a peremptory notice to the person who has been commissioned to designate an executor within such period. If no notice of the designation by the person commissioned has been given within such period, he shall be deemed to have declined such commission to designate an executor. Article 1095. Cases in which no designated executor exists. If there exists no designated executor pursuant to the provisions of Articles 1093 and 1094, an inheritor becomes an executor. Article 1096. Appointment of executor by court. 1. If there exists no executor, or if no executor remains due to death, ineligibility, or any other cause, the court shall appoint an executor upon the application of an interested person. 2. If the court appoints an executor, the court may order said executor to effect the necessary dispositions with respect to his performance. Article 1097. Acceptance or renunciation by executor. 1. An executor by designation must notify the inheritor whether he will accept or decline the designation of executor without delay after the death of the testator. 2. An executor by appointment must, upon receiving the notice of appointment, notify the court without delay whether he will accept or decline the appointment. 3. The inheritor or any other interested person may, by fixing a reasonable period, give peremptory notice to the executor by designation or appointment to give a definite answer within such period as to whether he will accept or decline becoming an executor. If no definite answer to the peremptory notice has been received within such period, it shall be deemed that the executor has accepted designation or appointment as executor. Article 1098. Ineligibility for executor of will. A person with limited capacity or a person declared bankrupt shall not become an executor of will. This article wholly amended by Act No. 10,429, March 7, 2011. Article 1099. Executor's undertaking of duties. If an executor accepts his office, he must perform his duties without delay. Article 1100. Preparation of inventory of property. 1. If a will has been made about property, the executor by designation or appointment must, without delay, prepare an inventory of the inherited property and hand it over to the inheritors. 2. If an application is made by the inheritors, an executor must allow the inheritors to participate in the making of the inventory of property mentioned in paragraph 1. Article 1101. Rights and duties of executor. An executor has the right and duty to manage the property which is the subject of a testamentary gift, and to perform acts necessary for carrying out the will. Article 1102, Joint Execution. Where there exist two or more executors, the conduct of their duties shall be decided by the majority, provided that each executor is entitled to effect acts of preservation. Article 1103, Status of Executor. 1. An executor by designation or appointment shall be deemed to be a representative of the inheritor. 2. The provisions of Articles 681 through 685, 687, 691 and 692 shall be applied mutatis mutandis to executors. Article 1104, Remuneration for Executor. 1. When a testator has not provided remuneration for an executor in his will, the court may determine remuneration for the executor who assumed office by designation or appointment by taking into consideration the status of the inherited property, or any other circumstances. 2. Where the executor receives remuneration for his service, the provisions of Article 686, 2, and 3, shall apply mutatis mutandis. Article 1105, Resignation of Executor. Any executor who assumed office by designation or appointment may, if there exists any justifiable reason, resign his office with the permission of the court. Article 1106, Removal of Executor from Office. If an executor who assumed office by designation or appointment neglects his duties, or if there exists any unfavorable reason, the court may, upon the application filed by the inheritor or any other interested persons, remove the executor from his office. Article 1107, Expenses relating to execution of wills. Expenses relating to carrying out a will shall be defrayed from the inherited property. Section 5, Withdrawal of Wills. Article 1108, Withdrawal of Wills. 1. A testator may at any time withdraw the whole or part of his will by creating another will or by an act inter vivos. 2. A testator may not waive the right to withdraw his will. Article 1109, Conflict of Wills. If a prior will is inconsistent with a subsequent will, or if an act inter vivos, after a will has been made, is inconsistent with such will, the prior will shall be deemed to have been withdrawn with respect to the parts in which they are inconsistent. Article 1110, Withdrawal of will in case testamentary document, etc. is destroyed. If a testator intentionally destroys the testamentary document or the subject of a testamentary gift, he shall be deemed to have withdrawn the will with respect to such parts as have been destroyed. Article 1111, Revocation of will subject to charge. If a person who has received a testamentary gift subject to a charge does not perform the duty which he has assumed, the inheritors or executors may fix a reasonable period and give peremptory notice demanding his performance, and if no performance is effected within such period, they may apply to the court for the revocation of the will, provided that such action shall not prejudice the interests of third persons. Chapter 3, Legal Reserve of Inheritance. Article 1112, Persons with right to legal reserve of inheritance and legal reserve of inheritance. Legal reserve of inheritance for an inheritor shall be calculated according to the following subparagraphs. 1. For lineal descendants of an inheritee, 1/2 of the inheritance stipulated by law. 2. For the spouse of an inheritee, 1/2 of the inheritance stipulated by law. 3. For lineal ascendants of an inheritee, 1/3 of the inheritance stipulated by law, and 4. For brothers and sisters of an inheritee, 1/3 of the inheritance stipulated by law. This article newly inserted by Act No. 3051, December 31, 1977. Article 1113. Calculation of legal reserve of inheritance. 1. A legal reserve of inheritance shall be calculated as the sum of the values of the inherited properties and the given properties at the commencement of inheritance minus the total amount of debts of the inheritee. 2. The value of a conditional right or of an uncertain right and validity of duration time shall be determined by the assessment of an appraiser appointed by the family court. This article newly inserted by Act No. 3051, December 31, 1977. Article 1114. Gifts to be added to. Gifts that have been given only within the period of 1 year preceding the commencement date of the inheritance shall be included for the assessment pursuant to the provisions of Article 1113. Exception applies to the property given before the period of the 1 year preceding, if the both parties concerned recognize that the act would cause loss to a person with the right of legal reserve of inheritance. This article newly inserted by Act No. 3051, December 31, 1977. Article 1115. Recovery of legal reserve of inheritance. 1. When there are shortages in the legal reserve of inheritance due to gifts or testamentary gifts made by the inheritee pursuant to the provisions of Article 1114, persons with the right to legal reserve of inheritance may recover the shortage. 2. With respect to paragraph 1, when 2 or more persons receive the gifts or testamentary gifts, they shall return the same proportions as their shares of the testamentary gifts. This article newly inserted by Act No. 3051, December 31, 1977. Article 1116. Sequence of return. Gifts cannot be demanded to be returned until testamentary gifts have been returned. This article newly inserted by Act No. 3051, December 31, 1977. Article 1117. Extinctive prescription. The right to demand the return in this chapter shall be extinguished by prescription, if it is not exercised within 1 year from the time when the person entitled to a legal reserve of inheritance becomes aware of the fact that the inheritance has commenced and that gifts or testamentary gifts, which are to be returned, were made. The above right shall also be extinguished by prescription if 10 years have elapsed from the time of the commencement of the inheritance. This article newly inserted by Act No. 3051, December 31, 1977. Article 1118. Provisions to be applied mutatis mutandis. The provisions of Articles 1001, 1008, and 1010 shall apply mutatis mutandis to legal reserve of inheritance. This article newly inserted by Act No. 3051, December 31, 1977.